When searching for a lawyer, it's important to remember to look for somebody who specialises in or has a greater knowledge in the area of law applicable to your matter. For example, if you and your former partner have separated and you have property and/or children together, it's recommended that you search for a family lawyer as opposed to a commercial lawyer. There are a number of ways that you can search for a lawyer. You may have heard about a lawyer from a friend or a colleague. Often a referral is the best way of selecting a lawyer because the person who provides that referral will typically have had a good experience and outcome with that lawyer. The Queensland Law Society website also provides a service whereby you are able to search for area of law or law firm. The service allows you to search for area of law, specialist accreditation, or location. Community legal centres also provide free legal advice. In Brisbane, there's the Women's Legal Service, who provide free legal advice to women in the areas of family law, domestic violence, child support and child protection. There's also the Caxton Legal Centre at South Brisbane, which provides free legal advice in most areas of law. When you and your partner separate, it can be a difficult and highly emotional time, particularly when there are children involved. You may have many people saying to you that you need to seek legal advice, but you're unsure why. A lawyer will be able to help you identify the legal issues involved. It may be that your matter relates to property, children, divorce, or even the amendment or creation of a will. A lawyer will be able to help you identify the legal issues involved, prioritise any action that is required, including any time limits that are involved, and provide you with the relevant advice and the most appropriate course of action moving forward. Before you attend your initial consultation, you should spend some time thinking about your matter. Think about what outcome you're wanting and how best you might achieve this. As any issues or questions pop into your head, you should jot these down on a piece of paper and take them with you to your initial consultation. The initial consultation itself can be quite an overwhelming experience as you recount your story to your lawyer. It may also be that you experience mental blanks, and your notes can be an excellent source of reference should this happen. The notes will also help to ensure that you have all of your questions and issues addressed and you don't leave your consultation having anything unanswered. It is not crucial that you take anything with you to your initial consultation. However, there may be documents that assist your lawyer in providing their advices to you. This will depend on the circumstances of your matter. Documents that may assist include current or previous court orders, any court material that you may have been served with, such as an initiating application or affidavit, or a letter from your former partner or their lawyer. The purpose of an initial consultation is for you to provide your story to the lawyer so that they are able to provide you with relevant advices. The advice that they provide to you is based on the information that you provide to them. Therefore, it's important that you are open and honest with your lawyer and don't leave out any information. Your lawyer will soon tell you what's relevant and what's not relevant. If you fail to provide your lawyer with some information, it may be that the advice they provide to you is incorrect, and this may have serious consequences for your matter. Your lawyer will then provide you with a likely outcome or range of outcomes for your matter, including if your matter is litigated in court. Your lawyer will then indicate the most appropriate course of action moving forward in your circumstances. Ultimately, it is your decision how you wish to proceed with your matter at the conclusion of the initial consultation. What you tell your lawyer is strictly confidential. Lawyers are governed by many rules and regulations and must adhere strictly to them. Lawyers cannot provide your information to anybody else unless you consent to it. All other employees within the firm are bound by the same rules and regulations. This means that you can feel comfortable and be open and upfront with your lawyer at all times. Typically, the best way to communicate with your lawyer is via email. Your lawyer will be available to talk to you over the phone, but email communication is the preferred method. Email communication allows your lawyer to provide you with written advices and directions and helps reduce any miscommunication. It also allows you to be able to reread the information at a later stage. You should be realistic in your expectations from your lawyer. They will not always be available to talk to you. It may be that they are with a client, that they are at court, that they are managing a large workload, or working to tight deadlines. It is important that you are patient and expect a reply within 24 hours. In turn, if your lawyer contacts you seeking your instructions, you should aim to respond as soon as possible to ensure that your matter can progress in a timely fashion. By law, lawyers are obliged to provide you with information regarding their costs. This includes information relating to their hourly rate, an estimate of how much they believe your matter will cost to run from start to finish, and any other costs and disbursements that may be applicable to your matter. Law firms calculate fees differently. Some calculate their fees based on a time basis, others on a task basis, or even a fixed fee basis. As an alternative, some law firms offer a capped price fee. What this means is that you pay an agreed sum of money into the lawyer's trust account. Any additional fees that are incurred above this agreed sum, you will not be required to pay. It's important to note that when a lawyer provides you with an estimate, it is simply that, and an estimate only. It is impossible for lawyers to provide you with an exact amount of what your matter will cost, given the uncertainty of legal matters. Finally, it's important to note that fees and charges vary greatly between law firms, and it is your responsibility to ensure that you understand the fee structure and what it is you will be required to pay. At times, your lawyer may ask you to read and sign documents. If you have problems reading or understanding such documents, say so. You should never sign a document that you cannot read or do not understand. Finally, if you do not understand something that your lawyer tells you, make sure you seek clarification. You should leave your lawyer's office having a greater understanding of your circumstances and situation. You should never leave being more confused or with unanswered questions. Remember, your lawyer is there to help.